Our next speaker is Ron Meisburg. Good afternoon, Mr. Meisburg. And then next up will be Professor Kaplan. Welcome.
Thank you, Madam Chairwoman, members of the board, good afternoon. My name is Ronald Meisburg. I'm with the law firm of Proskauer Rose, and I'm here to represent the United States Chamber of Commerce. We appreciate the opportunity to participate in this proceeding. There can be no doubt that the board's proposal raises very important issues for the labor management community. In the coming weeks, we're going to continue to work to identify and consider the issues presented by your proposal and to do the research and analysis necessary to draft and file comments by the August 22nd deadline. As we go forward, however, we believe that meaningful discussion in this area requires some mutual acknowledgement of some important points. The first is that employers have a legitimate and substantial interest in NLRB representation proceedings and the rules that govern them. While this may not be universally acknowledged, we think it's unassailable. After all, an employer undertakes risk, invests money, develops a business plan, makes commitments to vendors, suppliers, customers, hires and supervises the employees. And while the interest of employers may not eclipse those of other interested parties, they are undeniably legitimate and substantial, and they include the right of the employer to communicate effectively with its employees about unions and union representation. Second, we believe that a great number of employers involved in representation proceedings are relatively small. This is strongly suggested by the board's statistics showing that the median size of units in representation elections in the last decade is between 23 and 26 employees. And of course, that means half of the elections held involve less than that number. But the Chamber is particularly interested in this because more than 96% of the Chamber's members are small businesses with less than 100 employees, and 70% of those have less than 10 employees. Now, most of us here in this room are very familiar with the arcane labor law terms and rules and concepts involved in representation proceedings. And yet even we can sometimes struggle with their meaning and application. So we must not lose sight of the fact that a small employer, faced with perhaps its first and only organizing campaign, will not have anything like the familiarity and the expertise that we have. Instead, that employer will have to locate and retain counsel, and that takes time. While the stated goal of the proposed rules is to streamline the election process, we believe the rules must take into account the due process rights and realities of employers, especially small employers. Third, it must be acknowledged that a union does already have substantial advantages in a representation proceeding. The prevailing wisdom seems to suggest that it is the employer who holds all of the cards because purportedly it can, without regard to the demands of running its business, communicate constantly and incessantly with its employees about unions and unionization. On the other hand, it is the business of a union to organize and represent employees. A union may conduct an organizing campaign for weeks or months without an employer becoming aware of it. During that time, the union can frame the election issues, communicate them to employees, and determine what unit it wants to seek. The union can file the petition at a time when it feels it is most advantageous to do so. The union will have had the opportunity to consider and prepare for any anticipated legal issues, and will have its resources in place to handle that. Simply put, we think that under the current system, unions do enjoy significant advantages. So we believe that the proposed regulations and any suggested changes made for them need to be viewed through the lens of these facts. Otherwise, whether intended or not, there's a very significant and substantial risk that employers will be greatly disadvantaged in the exercise of their legal rights, both to respond effectively and appropriately to election petitions and possibly to communicate with their employees as well. And finally, there is no deficiency in the board's current handling of representation cases which demands changes contemplated by the proposed regulations. The Acting General Counsel has described the current representation case handling as outstanding. The board continues to meet its overarching representation case handling goals that are mandated in connection with the Office of Management and Budget, the Office of Personnel Management. Unions do not appear to be disadvantaged by the current system, winning upwards of 60% of the elections that are held. And we believe a system that processes 92% of the petitions filed on stipulation should not lightly be set aside or changed without a good degree of deliberation, in which we appreciate the board's opportunity for us to help you deliberate on this, and we look forward to further and full participation in this rulemaking proceeding.
Thank you. Mr. Meisburg, any questions?
I've got a question, and you can answer it in any of your roles. Private lawyer, former general counsel, counsel to the chamber, but I think you're well positioned to answer it in all those roles. Exactly. I've left one out. We made various, we put a set of options on the table in terms of blocking charges. And I'm just curious as to your view of what would be appropriate if we were to change the blocking charge policy. For example, the question of if one has a charge and if the general counsel has found merit in the charge, should we simply go ahead with an election? Should the ballots be impounded? If you have any preliminary views on that question.
Well, thank you, Member Becker. I do appear here today in one role, and that is to represent the Chamber of Commerce. And but it is informed, obviously, by my background and experience. I don't think there's any question that blocking charges, if you look, there was a, IG did an audit a few years ago of the board's representation case handling, and the blocking charges were routinely the outliers that brought up the median times for handling cases. So I think it's a very legitimate question for study. I don't have the answer to that here today. But I do say, and I have said in the past, I think the fact that the blocking charge may be responsible for skewing the statistics in a way is something that we'll certainly be addressing in our comments to you, and I think it is a very legitimate area for board inquiry. I wish I could be more insightful about that. I don't have an elegant solution for that this morning or this afternoon. I didn't have one this morning either.
Let me, oh, go ahead, please.
How you doing?
I'm doing all right.
Great. Good to see you. With respect to the statistic that you did cite, though, the 60% of the elections held being won by the union is probably even larger than that. But elections, wouldn't you agree that elections held is the key phrase?
Sure. I know that there is a complaint that say, well, there's a lot of petitions withdrawn. I don't know that these rules would address that issue. I mean, if that's what you're driving at.
Well, yeah. I mean, well, certainly if the argument on the other side of the issue is that if it ain't broke, because of the amount of success that unions have in the elections that are held, if we are to balance the ability of the parties to engage in collective bargaining with employee free choice and free speech, wouldn't you say part of our charge would be to make sure that if there is opportunity to file petitions, then they're not encumbered by process in order for us to do that?
I don't think there's any question that you want to have a process that is efficient and fair. And I don't think there's any, it's all going to be about the details of what results in that. My citing the 60% statistic was merely an effort to demonstrate that the current process is not so skewed that it results in, I don't know what a person would think needs to be the right number for that, but certainly it seems to me that any process that has resulted in 92% of matters being handled by stipulation and results in a 60% win rate by unions, it is to me, within the range of a reasonable system. There will never be a perfect system, and I understand we can't stop aiming at trying to improve things, but I don't think that the question about the percentage of wins and losses is more of a matter of trying to demonstrate that the current system is a reasonable system.
Anything further?
I guess I just have one question. It goes back to something that Mr. Kramer raised. In terms of what we have done in this proposed rulemaking, we have essentially, with respect to walking charges, we haven't proposed anything specific, but invited a conversation in the first place. That's to be contrasted with everything else that has been done in the rule, where it's very specific in terms of exactly what we would do. On reflection, would we have been better off, do you think, to have invited the conversation about the entire R-case situation, rather than just doing that selectively with respect to the blocking charges?
Well, you know, I don't, you sit in the seats of responsibility, I do not, and so I feel a little bit reluctant to second-guess discussions that were had that I wasn't party to, that may have involved matters that I don't know about. But I can say that I do think in this kind of rulemaking, which is going to affect, it'd be the biggest change in the representation rules in the history of the board. I think that a time of deliberation before proposing, along with an opportunity to have pre-proposal input, particularly since the board deals with, for example, the ABA regularly, other groups regularly. There are ready avenues of communication and thought available. I know when I was back early in my career at the Labor Department, and we did pre-proposal rules where we got comment from the regulated community before we even made a proposal. I don't think that would have been a bad idea, but I don't want that to be taken as somehow I know all that you know, and therefore I'm telling you what you should have done. But I do think that idea has merit.
Thank you. Anything else? Thank you for being
Thanks
with
very
us
much for
today
the
and for
opportunity.
your thoughts.